Welcome to the final part of this three-part series on Dennis Sochor. We told you about the disappearance of Patricia Gifford on New Year's Eve, 1981, about a night that started as an ordinary party and ended with a young woman who was never found again. And we told you about the trial where the jury, in a contested 10-2 vote, recommended the death penalty, a sentence that became final in 1993 after even the U.S. Supreme Court briefly weighed in. Today, nearly 40 years on death row, a years-long legal battle involving his own brother, and the final weeks before an execution that by now had been almost 5 decades in the making. Dennis Sochor was convicted in 1987 of kidnapping and murdering 18-year-old Patricia Gifford, whose body was never found. The key witness against him was his own brother Gary, who it later turned out had been granted immunity from prosecution. The jury recommended the death penalty by a vote of 10-2, which in almost any other American state wouldn't have been enough for a death sentence. In 1993, after a stop at the U.S. Supreme Court, the conviction became final. Since then, entire generations have come and gone. Children born around that time are now themselves older than Patricia Gifford was when she died. The world in which Dennis Sochor was convicted had no internet, no DNA databases like the ones we know today, and a completely different approach to handling suspects, witnesses, and evidence. And yet, despite everything changing around it, this one case kept moving through the legal system for decades. You'd think that would close the chapter. Far from it. What follows is one of the longest post-conviction fights you'll find anywhere in the American legal system, a fight spanning nearly 2 decades, during which 6 separate motions for relief were ultimately filed with the court in Broward County. Starting in 2009, Sochor began a long series of appeals following his final conviction. The core of his argument, the prosecution had allegedly failed to disclose that Gary had been granted immunity, and that this fact wasn't revealed to him until one day before his testimony. These kinds of filings are called post-conviction motions, legal jargon for appeals filed after all the ordinary avenues of appeal have already been exhausted. They exist for exactly this kind of situation: new information, or the realization that something went seriously wrong during the original trial that only comes to light years later. In 2016, Sochor filed a new motion, this time claiming there was new evidence. Gary had allegedly told a friend that he himself had been involved in the murder, something the defense says was never disclosed to them. Detectives, it turned out, were still trying, even years later, to get information from Gary about where Patricia Gifford's body might be, which suggests that even law enforcement itself was never fully convinced they had the complete story. That detail alone would raise questions for a lot of people. If police themselves, 40 years after the murder, are still trying to find out through the convicted killer's brother where the body is, what does that say about how certain the justice system itself is of the full story? Don't forget, no body was ever found. There has never been physical evidence that definitively confirms how, where, or by whom Patricia Gifford was killed, aside from Dennis Sochor's own confessions. Alongside the legal battle over his brother, Sochor's attorneys also argued that his original trial failed to adequately address mitigating circumstances: a childhood marked by abuse, mental illness, brain damage, and substance abuse. His prior service as a U.S. veteran was also raised as a factor. Claims like these, that the defense failed to adequately investigate a defendant's background during the original trial, come up remarkably often in American death penalty cases. There's even a specific legal term for it: ineffective assistance of counsel. The idea behind it is that every defendant has a right to a thorough defense, and that if an attorney at the time didn't devote enough time or resources to investigating their client's life history, that could have unfairly affected the eventual sentence. After all, a judge who had known about, say, severe childhood abuse or brain damage might have weighed the aggravating and mitigating circumstances differently. Claims like this, however, are notoriously difficult to win. Courts apply a high bar. It's not enough to show that an attorney could have done something better in hindsight. The defense has to show that the strategy chosen at the time fell so far below professional standards that it's reasonable to believe a different approach would have led to a different outcome. That's a heavy burden of proof, and it helps explain why claims like this, including in Dennis Sochor's case, were ultimately rejected time and again. Before the murder of Gifford, Sochor had already been convicted of the kidnapping and rape of a woman in Oakland Park in 1980, for which he received 1 year in jail and 5 years of probation. Prosecutors at the time used this pattern to argue for a harsher sentence. It's a detail that plays a double role in this case. On one hand, it supports the prosecution's argument that there was a pattern of violent behavior toward women. But on the other hand, ironically, it also supports the defense's later argument that there was underlying psychological trouble that was never thoroughly investigated or treated. This long string of appeals, from 2009 all the way through the sixth and final attempt following the 2026 death warrant, shows just how drawn out the post-conviction phase of an American death penalty case can become, sometimes stretching on longer than the original trial itself. Alongside the courtroom, there was another avenue open to him, and it's worth mentioning briefly because it comes up in a lot of American death penalty cases: clemency. In Florida, the power to grant clemency, or to commute a death sentence to, for example, life in prison, rests with the governor, together with the Florida State Board of Executive Clemency. This is a purely political process, separate from the courts, and the governor isn't required to give any reason at all for a decision to grant or deny clemency. In the lead-up to Sochor's execution date, various advocacy groups, including anti-death penalty organizations and Catholic social justice groups, publicly called on Governor DeSantis to consider clemency. They pointed to his advanced age, his decades in detention, his status as a veteran, and the lingering questions about his brother Gary's role. Petitions were launched and supporters were urged to call the governor's office. This kind of public pressure rarely changes the outcome, but it is part of the broader picture of how an execution in America unfolds in the weeks beforehand, not just in the courtroom, but in public opinion among advocacy groups, and ultimately on the desk of a single politician who holds the final say. It's worth drawing a distinction here between two very different kinds of doubt at play in this case. One kind of doubt concerns whether Dennis Sochor is actually responsible for Patricia Gifford's death. On that question, based on what we've been able to find, there's no substantial evidence of innocence. Sochor confessed himself multiple times. The other kind of doubt is about something else entirely, namely whether his brother Gary's exact role was fully and honestly presented to the jury, and whether the death penalty, given a non-unanimous jury recommendation and possibly under-investigated mitigating circumstances, was the right outcome. Those are two fundamentally different questions, and it's exactly that distinction American courts have had to grapple with, again and again in recent years. Now we come to this year's events. On June 10th, 2026, Governor Ron DeSantis signed Dennis Sochor's death warrant. It was the 11th death warrant DeSantis signed that year in a state that had already carried out a record 19 executions in 2025. To put that in perspective, less than a week before Sochor's warrant was signed, another inmate, Andrew Lukehart, was executed in Florida for a murder that had taken place 30 years earlier. In the summer of 2026, Florida found itself in the middle of what can fairly be called an unprecedented pace of executions. After the death warrant was signed, Sochor filed his sixth and final successive motion for relief with the court in Broward County, raising two separate arguments. The first argument concerned that 2022 letter in which police asked his brother Gary for help finding Patricia Gifford's body, a letter that, according to Sochor's attorneys, had been withheld in violation of the Brady and Giglio rules. Giglio, named after another high-profile American case, is closely related to the Brady doctrine we discussed last time, and deals specifically with information that could undermine a witness's credibility. Sochor's final legal argument was unusual and deserves to be explained in detail. His attorneys argued that the sedative used in Florida's 3-drug protocol, etomidate, doesn't keep an inmate unconscious for longer than 5 minutes. They claimed the combination of drugs causes pulmonary edema, in which the lungs fill with fluid, producing a sensation of suffocation while the inmate may still be conscious. As an alternative, they proposed execution by firing squad, arguing it would cause unconsciousness within 3 to 5 seconds, and would therefore be more humane than the current method. The court rejected this argument for a specific reason. According to the judges, the evidence this claim was based on had been available since 2017, the year Florida first began using etomidate as part of its protocol. In other words, the court ruled that Sochor's attorneys could have raised this argument much earlier, and that it was too late to bring it up now, right before a scheduled execution. The court also noted that similar objections to the protocol had already been repeatedly rejected in earlier cases. It's worth pausing on why objections to execution methods like this come up so often in American death penalty cases. Since the 1980s, lethal injection has become the standard method in most states, largely because at the time it was seen as more humane than alternatives like the electric chair or the gas chamber. But the exact makeup of the drug cocktail has kept changing over the years, partly because pharmaceutical companies, often under pressure from anti-death penalty advocates, refuse to keep supplying their drugs for executions. That forced states like Florida to keep searching for new drug combinations, like etomidate, whose precise effects in this specific application haven't been studied as extensively as drugs that have been in use for decades. That's why nearly every new execution protocol in a state like Florida eventually gets challenged in court, usually citing the Eighth Amendment to the U.S. Constitution, which bans cruel and unusual punishment. There's an echo here, by the way, of something we discussed in the previous episode. Just like the non-unanimous jury recommendation from 1987, which would still be valid under Florida's current law today, the timing of a case can also be decisive when it comes to which execution protocol rules apply. An inmate who went through the exact same process 20 years earlier or 20 years later could, in some respects, have ended up facing completely different laws. On July 8, 2026, the Florida Supreme Court unanimously rejected this final appeal. All 7 justices voted against staying the execution. The court also dismissed the complaint about the 2022 letter, ruling it had been filed too late and lacked sufficient legal grounds. The execution was scheduled for Tuesday, July 14, 2026, at 6 p.m. at Florida State Prison in Stark. On the day of the execution itself, Sochor made one final attempt. His attorneys asked the U.S. Supreme Court to step in and issue a stay. On Tuesday, without comment, the court denied the request. With that, every possible avenue had been exhausted. Dennis Sochor was executed by lethal injection at Florida State Prison in Stark. He was pronounced dead at 6:16 p.m., 16 minutes after the process began. He declined a last meal and spent his final hours with one visitor and a spiritual advisor. When the warden asked if he had any final words, Sochor said he did. He apologized several times to the Gifford family, said he was deeply sorry for what he had done, and thanked his own loved ones for their support over the years. After the execution, Patricia Gifford's family released a statement, and we want to end this series with their words rather than our own, because this whole series has really been about a case where the victim too often disappears behind the legal details. Patricia's brother, Bob Gifford, said that her killer's conviction and sentencing back in 1987 had given the family, quote, a measure of justice, consolation, and closure in knowing that he would never again be free to hurt another woman, end quote. He also said that when Sochor confessed in 1987 and led detectives to the Alligator Alley area in an attempt to locate Patty, the family came to understand that her remains would likely never be recovered. Quote, today marked the end of a legal process that lasted nearly half a century. Patty's remains were never recovered, but her life was never lost to us. She was our sister, our daughter, our friend, and she mattered, end quote. Patricia's sister, Marilyn Gifford, witnessed the execution in person. Afterward, she said Sochor's death brought the family some closure, but that it remained bittersweet since her sister's body has never been found. She pointed out that Sochor spent more than 45 years on death row, more than twice as long as Patricia got to live her entire life, and she left the public with one last request. If anyone has any information that could lead to the recovery of Patricia's remains, to please come forward. A bit of broader context, because it says something about where this case sits within a larger pattern. Sochor's execution was Florida's 10th of the year and the 16th in the entire country, meaning Florida alone has now carried out more executions in 2026 than every other death penalty state combined. He was also, at 74, the oldest person Florida has executed in its modern history, a record that had been set only weeks earlier, on June 25th, by another 74-year-old inmate just a week younger than him. Later this month, Florida is scheduled to execute an 80-year-old man, which would break the record again. Whatever you make of that trend, it's hard to look at it and not see a death penalty system increasingly executing people who have spent decades, not years, waiting for this outcome. None of this brings Patricia Gifford back, and none of it undoes the 45 years that came before it. What this case exposes, more than anything, is just how long the American legal system can take to reach a final answer, and how much can remain unresolved along the way. A body that was never recovered, a brother whose full role was never entirely settled, and a non-unanimous jury vote that, under the law as it stands today, would still be considered valid. It also says something about how we, as a podcast, try to handle cases like this. Across these 3 episodes, we've tried to stay as close to the facts as possible. What happened that night in 1981? What was said during the trial? And what happened legally in the decades since? We've deliberately avoided passing judgment on whether Dennis Sochor deserved the death penalty. That was never ours to decide. What we could do is show just how complicated, how drawn out, and how uncertain a case like this really is in practice, even one that ended exactly the way the state of Florida intended all along. That was the 3-part case of Dennis Sochor. Next week, we begin a new case.